Good afternoon, everyone. Welcome to the meeting of the Judiciary Committee. The meeting is hereby called to order. Madam Secretary, please call the roll.
Representative
Secretary, please call the roll.
Representative Blanton. Representative Bratcher.
Here in the room.
Representative Cantrell. Representative Decker. Representative Elliott. Representative Fisher.
Here in the room.
Representative Hebron.
Present in the room.
Representative Cole-Carney.
Present in the room.
Representative Lewis.
Present in the room.
Representative Maddox.
Present in the room.
Representative McCoy.
Here.
Representative Minter.
Here.
Representative Mosier.
I'm here in the room.
Representative Nemus. Representative Petrie.
Present remotely from my annex office.
Representative Scott.
Present.
Representative Stevenson.
Present in the annex.
Representative Banta.
Present in the room.
Chairman Massey.
Here in the room, we do have a quorum. As always, before we begin, I would caution everyone to put their phone on airplane mode because the signals sometimes interferes with our equipment, which is very sensitive, and just being mindful of that. Today, we actually initially had two bills for consideration. One we have passed over for this moment, and you may be attuned to that in the future. So with that, we have one bill for consideration. That is House Bill 230, sponsored by Representative Meade, who is here and ready to present. So Representative Meade, you have the floor.
Thank you, Mr. Chairman and members of the committee. I think there is a committee sub, Mr. Chairman, if you would like to get that before the committee.
We have a motion on the sub and a second. All in favor signify by saying aye. Aye. Those opposed? There is none.
All right, thank you all very much. House Bill 230 affirms legislative authority and the separation of powers by making it clear that the General Assembly may defend the constitutionality of the laws that we pass, but we may not be hauled into court every time someone doesn't like the law that has been passed. Section 1 allows for intervention on behalf of the bodies. Section 2 makes it clear that there is no waiver of immunity or privilege. And Section 3 reaffirms that in all matters, legislative immunity and privilege shall be applied and interpreted as broadly as the Constitution allows and shall not be waived unless that waiver is specific and explicit. It's necessary to make it clear that leadership of each house has standing to intervene without any waiver of legislative immunity or legislative privilege on behalf of their respective chambers or together for the General Assembly as a whole. As currently written, it allows leadership only to intervene in an existing court challenge challenging the constitutionality or validity of any legislative act, statute, executive order, administrative regulation, or order of any executive agents. Because the General Assembly is not in continuous session, it has been unclear whether the General Assembly is entitled to any voice at all during the interim in litigation. So this will clarify that we may have a voice, but Section 2 ensures that no legislator's immunity is waived and no legislative privilege is waived. And finally, in Section 3, it affirms the ancient doctrine and legislative immunity and privilege contained in our Constitution in Section 43, the Speech and Debate Clause. The doctrine of legislative immunity and the declaratory judgment Act are very clear that legislators and legislative bodies are immune from suit, even if the suit for judgment requests no damages or other relief, and shall not be named as defendants in any action seeking to declare legislation unconstitutional. The proper course is to sue, of course, the party responsible for enforcement and seek an injunction against enforcement of an unconstitutional law. And
Motion on the bill, Mr. Chairman.
All right, we have a motion on the bill and a second. Are there any questions? Who do we have? Representative Scott, please proceed.
Thank you, Chairman Massey. I have a couple of questions. The first one is I just want to know what's the difference between the original bill and this substitute.
The original bill did not have a timeline for us to make a filing, and in the sub, it just adds that the filing must be done within 90 days.
Thank you, if I may. Thank you. And then my next question is, why is this bill necessary? Because this, to me, is an executive branch authority, so why are we now bringing it over to the legislative?
Many times when the constitutionality of these laws are challenged, there may not be someone to challenge the constitutionality. The AG previous years may not have wanted to challenge it, but this gives the opportunity for the General Assembly to uphold and defend the constitutionality of any of the bills that we pass when we feel it's necessary. We represent the people, we're the voice of the people, and we should be standing up for the people in the court, and that's the reason for it. I can. I have my thoughts and ideas of it, but I will let our general counsel for the Speaker's office, Eric Lykin, I'll let him answer.
Well, Representative also say it's often that it's the executive branch challenging the constitutionality of an act, so that the executive branch is not there to defend it. So this bill just allows the General Assembly, through its officers, to defend the acts that it passes. And because we're not in continuous session, this Section 1 identifies the constitutional officers who do exist when we're not in session as having the right to intervene.
Thank you, Chairman, and I'm so glad, Representative, you could hear my question because my mic wasn't even on, so appreciate your responses.
Thank you. Representative Kulkarni.
Thank you, Chairman, and thank you for presenting this bill. I just had a question about the impact of this legislation on open records and whether or not there would be any, and also with regard to questions of First Amendment protected speech, whether that is addressed or impacted with this at all, because you're talking about constitutionality of these matters.
We're specifically talking about the case and waiving any immunity related to these when we're intervening. And just like our constituents, when they send us information through our emails, whatever it may be, there are confidential things that don't need to be out there in the public, and so that just upholds those things and not waive that legislative immunity when it comes to these acts in court.
Representative Nemes.
Thank you, Mr. Chairman. I want to thank the Speaker for bringing this bill. This is an important step in the evolution of the legislative independence. I would note a couple cases I think that are really important. Rose versus Council, which is something that most people are very proud of in the Commonwealth of Kentucky. Two of the parties in that case were the Speaker of the House and the President of the Senate. And that case led to historic changes in the way we fund our education system throughout the Commonwealth of Kentucky. Powell versus McCormick, which is a case from the federal courts, talks about the legislative immunity. That's one of the provisions of this bill, which is to say that it's important that we have legislative immunity, and that is recognized in Kentucky in a case called Baker versus Fletcher, where the legislature was sued, and the Kentucky Supreme Court noted that upheld the legislative immunity portion, which I think is Section 2 and 3 of your bill. The reason that this is so important, and I would also note that particular legislators have tried before to have standing. Jim Wayne was the most recent one in a case with Bevin and Bashir involved. And the Kentucky Supreme Court said individual members do not have standing because they don't speak for the body in the way that the President of the Senate and the Speaker of the House do. But the reason this is so important is because if there is something that is challenged and no one is there to defend it, whether it's a party issue or whether, for whatever reason, the people's laws that were enacted through its duly elected legislature should be defended by some entity. And in some ways, the legislature has facts that bring to bear on a situation that others don't. A perfect example is one that's going on right now, where a member of the General Assembly and 5 citizens and the Kentucky Democratic Party have filed a lawsuit against the Board of Elections and the Secretary of State. And that's fine. But the real party and interest in that claim is the legislature. And so if the Speaker of the House and if the President of the Senate or one or the other decide to intervene, that's an important step that should be allowed to be taken. It would, I believe, be allowed to be taken already, but what this statute does is it makes it crystal clear that if the legislature is the real party in interest, and if they are not part of the suit, they can intervene and assert the interest of the people's representatives. So I think this is a very important bill. I think it's one that is quite frankly non-controversial, and so I look forward to voting for this bill and hope others will stand up for the independence of the legislature as well. Imagine if this had been brought a number of years ago when we might have not agreed with the particular governor, if it were a Republican or a Democrat. It's important that the legislature have the right to intervene. If it were Fletcher governor, Stumbo could have intervened. If it were obviously a Democrat governor, a Republican can intervene. This is a separations of powers issue, that I think it would already be recognized in the courts, but it's important that we, as a legislature, codify in our statutes. Thank you, Mr. Chairman.
Representative Cantrell.
Thank you, Mr. Chair. I have a question and maybe a comment. I think this bill's really interesting because I've been teaching a class at U of L Law School about legislation and statutory interpretation, and this is sort of the mix of the two. In that class, we talk a lot about how to find legislative intent, and I think about that a lot as, you know, one of 138 members of the General Assembly trying to find legislative intent is really, really difficult because we all have different opinions. And if you asked us why we voted for or against a particular piece of legislation, you would get 138 different answers. So a court trying to find one answer is really difficult. And I tell you that to ask this question. You know, especially right now, the Senate and the Senate President and the Speaker of the House are all of the same party. So how would minority concerns and minority voices in litigation be represented? So if a particular party voted one way on a bill and the minority party voted the other way, and there were, you know, legitimate concerns that are probably the same concerns that are brought up in the litigation, how would those be expressed in a fair manner representing the entire General Assembly?
Well, again, in this bill, we're not really focusing on legislative intent. We're focusing on the constitutionality of a bill. And so the Speaker and the President represent the entire body. So they should be operating in a manner that is bipartisan and for the good of the Commonwealth. And therefore, it wouldn't matter who the Speaker is, what party they're a part of, and of course, as Representative Amos said, this is for years down the road. It could be someone else of another party that is Speaker or the President at that time. So that should not matter. It should be what's the best for the Commonwealth and operating in that manner.
I really appreciate that answer, and I'm just going to make this is a separate point. I'm going to talk about, I guess it's Section 4, talking about how legislative immunity and legislative privilege, the language says shall be applied as and interpreted as broadly as constitutionally permissible. I have a little bit of a concern about that language. Just it gets into a little bit to me about telling courts how to interpret something and getting to a little bit of separation of powers concerns. I'm happy to talk to you more about that and see if there's a way to clarify that a little bit better. But that's a road I'm not really interested in going down. So thank you, Mr. Chair, and thank you for answering my first question.
Seeing no other, Representative Minter.
Quick follow-up. Thank you, Mr. Chair. Quick follow-up on Representative Cantrell's question about the Section 2 about legislative immunity. Does this conflict in any part with existing, not anything the legislature might seek to modify during this session, but with existing interpretation of the Kentucky Open Records Law as written or as interpreted by the courts currently?
In my opinion, I don't see that in any way. I'm happy for Eric to.
I don't believe it does, Representative Minter, because as it's currently constituted, the Open Records Act does not apply to the legislative branch.
So just to follow up, does this expand that in any way that it might create a conflict?
Sorry, I don't see how it would create a conflict. Does it expand the independence of the legislature and probably provide more protection for its records? It would if the Open Records Act applied. So yes, but it like, for example, your constituents may communicate with you, and this should be intended to say that your communications with your constituents, with your colleagues, et cetera, are covered by legislative privilege and can't be invaded by the courts.
Okay, so this does expand it slightly beyond what already exists for legislative privilege.
I don't know that I would agree with that characterization,
okay.
but
okay, and
it's
that's
fair.
Clarification.
It's fair enough.
Yeah, looking for clarification. Thank you.
I believe Representative Nemus has a comment.
Yeah, and Mr. Chairman, I don't think, and I think I agree with the colloquy we just had. It does not expand the legislative privilege in any way. The legislative privilege was is in the Constitution. The bill we passed, I think a couple of years ago, maybe it was last year, talked about the Open Records Act as it applies to the legislature. By the way, the Open Records Act hasn't applied to the court system for a number of years. There's two cases, In re Auditor and Ex parte Farley, where the Kentucky Supreme Court said that the Open Records Act did not apply to the judiciary. So this doesn't affect that. What this, I think, would do is, in the context of a lawsuit, if the Speaker and or the President decided to intervene, that this in no way waives the legislative privilege that is already on the books. Thank you, Mr. Chairman.
Okay, seeing no further questions, we have a motion on the bill and a second. Mr. Secretary, please call the roll. This is as amended by the committee sub.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Cantrell,
May I just explain my vote really briefly? I'm going to pass. I'm going to cast a pass vote. And it just explained briefly. I think it's clear from my questions. I have a little bit of mixed feelings about this. I understand the intent, and I think it could be helpful in litigation and statutory interpretation going forward. But I do have some concerns, and I'm going to pass today.
Representative Decker,
Yes. Mr. Chairman, I'm sorry that I was late. I need to be marked present, and I vote yes. Thank you.
Representative Elliott, Representative Fisher,
Yes.
Representative Hebron,
Yes.
Representative Kulkarni,
I'm going to vote yes today, but I reserve my right if anything comes up, any implications, to vote no on the floor. Thank you.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative McCoy,
Yes.
Representative Minter,
I'm going to pass for today, and I have a few questions about it, so I reserve the right to change that on the floor.
Representative Mosher,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Scott,
No.
Representative Stevenson,
No.
Chairman Massey.
Yes. Thank you for your presentation, and we will, for the Judiciary Committee purposes, we passed over the other bill that was going to be heard today. We do have two other bills that have been referred to us. We're in discussions as to what the agenda will be for the following week. I will let you know as soon as I know, but we did have House Bill 48 and House Bill 154 have been referred to this committee. So if you have the time, please take the time. If you don't have the time, please take the time to read them and be prepared in case those are on the agenda for next week. With that, having no other business, we'll stand adjourned.
Thank you all.